History of English Law, 29 documents. The formal start of an English law of real property came after the Norman invasion of 1066, when a common law was built throughout England. The new king, William the Conqueror, started standardizing England's feudal rules, and compiled a reference for all land and its value in the Domesday Book of 1086. This was used to determine taxes, and the feudal dues that were to be paid. Feudalism meant that all land was held by the monarch. Estates in land were granted to lords, who in turn parceled out property to tenants. Tenants and lords had obligations of work, military service, and payment of taxation to those up the chain, and ultimately to the crown. Most of the peasantry were bonded to their masters. Serfs, cotters, or slaves, who may have composed as much as 88% of the population in 1086, were bound by law to work on the land. They could not leave without permission of their lords. But also, even those who were classed as freemen were factually limited in their freedom, by the limited chances to acquire property. The Commons Act 1236 allowed the lord of a manor to enclose any manorial land that had previously been common, and the Statute of Westminster 1285 formalized the system of entail so that land would only pass to the heirs of a landlord. The Statute Quia Emptores Terrarum 1290 allowed alienation of land only by substitution of the title holder, halting creation of further subtenants. The civil liberties of the Magna Carta of 1215, and its reissue in 1297, were only meant for barons and lords, while the vast majority of people were poor, subjugated and dispossessed.